Good morning, Mr. Franklin. Good morning, everybody.
Good morning, Chair.
Yes, are we ready?
Thank you, Chair. As you know, we continue today with the evidence of Mr. Symington.
Yes.
Before we do that, Chair,
Yes.
I had informed you earlier of an application brought by the State Security Agency in respect of the evidence to be led by Mr. Vlok Symington after Mr. Symington. There have been numerous interchanges between the parties, and a resolution has been reached, which obviates the need for the application to be argued. Counsel for the SSA is here and has asked the Commission's indulgence to place on record at this point that their attitude, so that he can then be excused thereafter. I understand that the representatives for Mr. Vlok Symington would similarly like to place certain matters on record if you allow them to do so after the SSA.
Okay, before I allow the SSA, I just wish to announce that at 2 p.m. this afternoon, I will make a public statement about the events of Tuesday evening in this commission, this past Tuesday, during the evening session of the commission. That will be at 2 o'clock at this venue. Okay, all right. And then also I just need to mention to you, Mr. Franklin, and all counsel and legal representatives present and the witnesses that we will take an early lunch today at 12:30, but we'll resume at 2.
Thank you, Chair.
Thank you. Counsel for the SSA can then address me.
Good morning, Chairperson.
Good morning.
Chairperson, I made an appearance yesterday.
Yes.
On behalf of Mr. Loiso Chafta,
Yes.
who is the acting Director General of the SSA. Chairperson, majority of what has been said by my learned colleague is correct. There has been numerous engagement and exchanges that necessitated that the whole application that was brought before this commission should be not argued or the motion moved. However, my client has a certain disquiet that I'm under instruction to ventilate in the commission. Chairperson, the need for us to enter an appearance in this proceeding was firstly premised on a constitutionalism. Chairperson, the fundamental constitutional principle is that an individual can do anything but that which is forbidden by law, whereas the government can do nothing but that which is authorized by law. So this is the tried principle of the law. So now, the acting general of SSA deemed it prudent to bring this honorable commission to certain principles of the law necessitated by the application. If I direct this honorable commission to Intelligence Services Act 65 for 2002, particularly Section 4, which reads as follows. The Director General must, as far as is reasonably practicable, take steps to ensure that identity of members of the agency are protected from unauthorized disclosure. Equally so, Chairperson, Section 26 of the same Act reads as follows.
A person commits an offense if he or she, not being a member, by words, conduct, or demeanor, pretends that he or she is a member, encourages a member not to carry out his or her duty, to perform any act in conflict with his or her duty. Now, Section 26(1)(a), Roman numeral 3 says, a person commits an offense if he or she discloses classified information or material entrusted to him or her by the Director General or a member without the permission of the Director General. Chairperson, equally so, which is legislation that we deem finds application in this situation, is Section 4 of the Protection of Information Act number 84 of 1982. And for the record, in fact, let me just quickly take it from jurisprudence, which is now established in our courts. In the Minister of State Security versus the Public Protector, this is a recent judgment, Chairperson. If this commission wants that I should give it a full citation, I will be glad to do so. Now, the general principle is that...
No, don't do so. Don't do so. How much time should I give you to make your address?
The last, perhaps about 5 minutes, I'll be done.
5 minutes more, okay.
5 minutes more.
Okay, all right.
If the chairperson goes to paragraph 17 of the judgment, chairperson will see in quotation at paragraph 17, page 10 of the judgment, it says, just because a secret document already is in the public domain does not justify its further disclosure by order of this court. This is now the judgment that came out recently. Chairperson, now when I looked at the affidavit of the witness that is about to testify, particularly at paragraph 83.
The one who will testify after the one who is about to testify.
To be precisely, Mr. Van Lochenbeck, Chairperson.
Yeah.
Chairperson, this is what he says at paragraph 83 of his affidavit. And I quote, I've always been and remain able and willing to implicate persons from the highest office of the land to ministers, deputy ministers, politicians, senior state officials, politically connected persons, big business and executive, the offices of the constitutional oversight bodies, members of parliament, head of state organs, law enforcement officials, secret agents, and operatives of the state, and many entities registered both in South Africa and elsewhere in the world. However, I do so and need to be permitted by law, by specifically SARS and the State Security Agency and Police Crime Intelligence to do so. Be afforded access to records that I know of, participated in compiling and oversaw, be afforded access to witnesses whom I know by name and worked with over the years, who I know and will be able to corroborate. Now, if I want to tidy up my submissions, Chairperson, today, I wish to state the following. Notwithstanding the legal principles that I've given to the Commission, the affidavit submitted by Mr. Van Lochenbeck in these proceedings, particularly the 3.3 that have been given by my client, I will not mention the names because these are some of the names that are protected. Now, if one has regards to paragraph 4, at the end it says the full statement of Mr. Van Lochenbeck will be uploaded on the Commission's website as soon as he concludes his evidence. The transcripts will be uploaded daily. Now, I'm mindful of the fact that we have reached a consensus where we say the names, particularly belonging to the list provided by Mr. Lochenbeck, will be redacted. The question now that remains is that what happens to those that has already been disseminated through 3.3 letters? They still remain in their original form. Chairperson, I do not make this submission very lightly. My instruction is that in its original form, the affidavit that was filed by Mr. Van Lochenbeck is in breach of Section 26 of the Intelligence Services Act. And this honorable commission cannot be used as an instrument to countenance such behavior. And I hope, and this is my client's instruction, that an investigation will be commissioned to know exactly under what circumstances was the names allowed to find themselves in the affidavit. These are my only concerns as far as my client is concerned. As I said, on the notice of motion, there are two prayers that are requested, one of which is evidence in camera, and the second of which is the reduction of names. As I've stated, Chairperson, that there is no longer a need for us to participate. And in fact, the last issue was insofar as the rule point 3. My understanding of the rules of the commission, Chairperson, if you allow me, is that 3.3 has a before. If perhaps for the record I need to read the rule itself, it says, if the commission's legal team intends to present to the commission a witness whose evidence implicates or may implicate another person, it must, and this is now couched in peremptory measures, through the secretary of the commission, notify the person in writing within a reasonable time before. So now my understanding is that the commission has gone through the affidavit of Mr. Van Lochenbeck, and the analysis was that none of our clients or none of our members are implicated. Otherwise, had they been implicated, they would have then received the 3.2 notices. 3.3, I beg your pardon, Chairperson. Chairperson, if there's anything else that you need me to address, that is the submission, or that is my instruction as far as my client is concerned.
No, that's fine. No, there is nothing. Thank you very much.
Thank you, Chairperson.
Thank you. And then, is it counsel for Mr. Van Lochenbeck?
Morning, Chair.
Good morning.
Chair, I'll be very brief. Mr. Van Lochenberg has requested that I make the following points, which will be in response to what my colleague has already put forward. The first point, Chair, is that Mr. Van Lochenberg has at all times been both cognizant of and respectful of the legislation governing the operations of the SSA. The second point is that the names that have been mentioned in his affidavit have in the main all been in the public domain for close to a decade, both through court process and through media coverage. Mr. Van Lochenberg took great care to only name those who have been listed in the public domain. He goes further to state that he could name many more, but due to the fact that those identities have not yet been exposed, he has taken every caution to avoid disclosing their identities. The third thing is that Mr. Van Lochenberg did not go out purposefully to seek out these individuals. The evidence presented by him came to his knowledge over time through the actions of these very operatives. Furthermore, whenever these actions came to his knowledge, he took extreme care to inform the SSA and to protect the SSA as best as he could. Mr. Van Lochenberg also does not seek to tarnish the entire SSA. That is most certainly not his intention. He's merely advising the Commission of those operatives who he deems it appropriate for the Commission to be aware of. When Mr. Van Lochenberg received the application from the SSA chair, it was he who initiated the dialogue to say, let's reach a compromise, let's redact those names. I personally, Mr. Van Lochenberg said, will go through my affidavit, redact the names, and insert pseudonyms. The last point Mr. Van Lochenberg wishes me to make, Chair, is that whilst he's aware, cognizant, and respectful of legislation, he does not believe that legislation can ever be used by individuals to protect or to clothe them from any unlawful behavior that they may have been guilty of. Thank you, Chair.
Thank you. Please sanitize the podium again. Yes, Mr. Franklin.
Thank you, Chair. I have nothing to add on the SSA issue.
Yes.
With your leave, may we continue with the evidence of Mr. Symington?
Yes, let's do so. Good morning, Mr. Symington.
Morning, Chair.
And the oath you took yesterday, or affirmation, whichever it was, will continue to apply this morning.
Thank you, Chair.
Okay. Okay, you may proceed, Mr. Franklin.
Thank you, Chair. Mr. Symington, we concluded with your main affidavit yesterday. What I'd like to do this morning is put further affidavits to you and get your comment on certain issues. Please would you get before you the file which is, the bundle which is SARS 03. You have that?
Yes.
And would you please turn to page 659? That's an affidavit which runs to page 697. Please look at page 697.
697, you said.
That's correct. I'm sorry, I've taken you too far. It is in fact page 688. You have that?
Yes.
It reflects that this affidavit was deposed to by you on the 24th of February 2021. Can you confirm that?
Yes, Chair.
And do you confirm the truth and accuracy of this affidavit, which is described as affidavit?
I'm sorry, Mr. Franklin, did you say page 688?
Correct.
On 688, I don't have an affidavit. I've got a picture of somebody. Professor Nkohlu.
Is the chair looking
I'm
at...
having SARS bundle 2.
No, 3.
Oh, okay. Six, eight, eight.
Do you have that, Chair? Just to orientate you,
688 is the pager.
Yes, that's the last page of the affidavit.
Okay,
And it begins at page 659,
okay.
and it is called Affidavit in Reply by Mr. Symington.
Okay, I've got the last page of that affidavit.
Thank you. And Mr. Symington, you have confirmed the truth and accuracy of the contents of that affidavit.
Yes, Chair.
Chair, Mr. Symington's main affidavit was Exhibit WW3. May I ask that this affidavit in reply be admitted into the record as Exhibit WW3.1?
Thank you. The affidavit. Oh, that affidavit starts at 659, is that right?
Correct.
Okay. You suggested it should be WW?
3.1, Chair.
Okay, the affidavit of Mr. Johann Daniel Vlok Symington, starting at page 659, will be admitted as an exhibit and will be marked as exhibit WW 3.1.
Thank you, Chair. Can I take you to your affidavit, please, Mr. Symington, and particularly paragraph 5 on page 660? You say there that various persons implicated in your main affidavit, which we went through yesterday, were duly notified of such by the Commission, and some have elected to file affidavits in response to certain allegations in your main affidavit, and you were provided with the affidavits deposed to by 4 named persons, and they are, I'll just use the surname for purposes of this exercise, Rapolo, Fissa, Makakela, and Motle. Is that correct?
Yes, Chair.
You also say in your affidavit that for purposes of responding to those statements, you consulted with various SARS employees. You say that in paragraph 13 on page 662. Is that correct?
Yes, sir, I did.
And can you confirm that on the 29th of January 2021, and for purposes of compiling this affidavit in reply, you consulted with SARS employees? Once again, I'll just use the surnames. Mr. Kingen, formerly Acting Commissioner of SARS and currently Head of Stakeholder Engagement. Broughton, Chief Litigation Officer of SARS. Inkabinde, a legal specialist, and Mosito, also a legal specialist. Is that correct?
Yes, Chair.
And you procured confirmatory affidavits where necessary to confirm what they told you at that meeting?
Yes, Chair, I did.
What you have done then is you have taken each of the affidavits in turn, and you have given your response to it. And I'd like to simply highlight some of the paragraphs in your affidavit. Please look at page 661. There's a heading, Response to Motle's Affidavit. And just to remind the Chair, Mr. Motle is the attorney who conducted the inquiry into your grievance against Mr. Titi. Is that correct?
Yes, Chair.
All right, please look then at paragraph 14. Paragraph 14, I understand to be a summary of what you were advised by the SARS representatives with whom you consulted. Is that correct?
On 14?
On
Yes,
page
Chair.
662.
Yes, Chair.
Could I please ask you to look at paragraph 14.6. Now, you told the Commission yesterday that there had been a report that had been drawn up by Mr. Motley, in which he had essentially upheld your version of events and found that there was fault on the part of Mr. Titi and that an inquiry should be convened in relation to Mr. Titi's conduct. Is that correct?
Yes, Chair.
You also explained that sometime thereafter, and I think you said effectively out of the blue, you then received an addendum report, and in the addendum report, for the first time, your conduct had been scrutinized and you were found to have committed misconduct. Is that correct?
Yes, Chair, indeed.
All right, so if you look then at paragraph 14.6 at page 663, you summarize here what you were told by the SARS officials with whom you consulted. Is that right?
Yes, Chair.
If I may then just take you through it. In summary, point 1, after he submitted his first report, Motley was called to a meeting held at SARS offices. 2, Motley was told that he had misunderstood the instructions. He disputed this. 3, he was instructed by R. Mokwena, together with Labello, to prepare an additional report which also dealt with my behavior. He was expressly pointed to the issue of my swearing as an issue to report on in a supplementary report. 4, he requested a letter about how he misunderstood the instructions, but never received such a letter. 5, after leaving, he shared his discomfort about the instructions in a discussion with Rapolo. And 6, with regard to the addendum report, no additional evidence was obtained prior to reaching the conclusions and recommendations. Can you confirm that is an accurate summary of what was told to you by the SARS officials?
Yes, Chair, indeed.
Then if I could ask you to turn to paragraph 21 on page 666. This is still part of your detailed response to Mr. Motley's affidavit. And please turn to paragraph 21.3. And this is what you say. The first report...
Is that paragraph 21.3?
Correct, on page 667, Chair.
Okay, thank you.
Do you have that, Mr. Symington?
Yes.
The first report can hardly be said to be incomplete or inadequate. This is most likely why Motley initially resisted instructions to, inverted commas, expand on his first report. Unfortunately, the irresistible inference to be drawn from the facts is that Mr. Motley was pressurized inter alia by R. Mokwena and Labello to frame me for misconduct, and that he ultimately buckled under this pressure and produced the addendum report, the sole purpose of which was to justify SARS taking disciplinary action against me. Now, you've reached a serious conclusion there. Perhaps you can please elucidate for the Chair what it is that leads you to this conclusion that the addendum report was aimed purely at framing you.
Chair, so I need to go slightly back in sequence and maybe start off where I was initially informed by SARS that Mr. Motley would be appointed to investigate my grievance against Mr. Atiti. It was made very clear after I've asked what the terms of reference would be for the investigation. It was made very clear to me, and by way of email, which is in one of my annexures, that the investigation will be focusing on the grievance which I lodged against Mr. Titi. And on that basis, the investigator, Mr. Moffley, produced a report dated 31st of May 2017, and then handed to me, I think, on the 11th of May of that year. And the report, in fact, went into my grievance, investigated it, interviewed me extensively, interviewed Mr. Titi more than once, and as a result, the report, which was then produced to SARS, found that my grievance was in fact valid. And then a series of interventions which happened behind the scenes, which we later found out about via emails that were provided to me by SARS, from the SARS email server. It was then found that a meeting was held between SARS representatives and Mr. Moffley, where Mr. Moffley was in effect pressurized by SARS to change the outcome of his report. And he then executed that, hesitantly so, and he expressed his sort of how he felt about it. He uses the word hesitantly, I'm saying unethically, then went back, used the exact same facts, exonerating Mr. Titi, and recommended 4 very serious disciplinary charges against me. Now, no one ever laid a complaint about me, not my line manager, Mr. Lowe, not Mr. Titi, no one filed any grievance against me, yet that was then the outcome. And and that led me to a conclusion that there was only one reason that the second report, or the addendum to the first report, was asked for, and that was to effectively remove me out of SARS. Because when you look at those disciplinary charges, each of them, if I was found guilty, which, by the way, I would not have been, but if so, any one of them would have led to my immediate dismissal out of SARS. No other warning letters or anything like that. And that's what led me to this.
Thank you. Then please look at 21.4 on page 667. What you have done there is to draw the Chair's attention to the introduction to the addendum report, and you say that the wording of that introduction supports the inference in the preceding subparagraph. The wording is at page 667, and it is as follows. 1.4, following the elucidation of the terms of our mandate, we accept that the additional elements of the incident that require specific investigation and recommendation include, inter alia, 1, the apparent breach of the employer-employee trust relationship by Symington; 2, an analysis of the content of the audio and video recordings released to the media to establish the true intent of the protagonists, brackets, Symington and Titi, close brackets, and the actual underlying circumstances and associated nuances of the incident, close quote. And in 21.5, you've said, it is suspicious, to put it mildly, that an independent attorney appointed to investigate my grievance against Titi, in which I allege illegal conduct by him and others, finds in his first report that on the probabilities Titi was complicit in holding me against my will, but then, without any further investigation, interviews, or even a communication to me, accepts an instruction to investigate an apparent breach of trust by me towards my employer. This is all the more disturbing to me if regard is had to the fact that Motley deemed it appropriate to interview Titi twice before he finalized his first report. As is apparent from my explanation of my resort to expletives and Motley's concurrence that such expletives were not directed at Titi, he then deemed it appropriate to canvass this particular issue with Titi again. And then you've made certain references. I think that is self-explanatory.
Yes, Chair, it is.
And then just to highlight one further issue in the first sentence in 21.6, you say that no such allegation was ever brought to my attention prior to the issuing of the addendum report. I was never asked to comment or respond to any such allegation. Is that factually correct?
Yes, Chair.
Then could I direct your attention to Mr. Kingen's confirmatory affidavit?
Mr. Chair, if I may,
Yes.
just before we go there, I think it's also relevant to know that when I was initially informed that Mr. Moffley would be appointed, I was informed of this on the 21st of November 2016 by Mr. Rafolo. And in that email, the very same individuals that later sat with Mr. Moffley to change the scope of the investigation, if you can call it like that, were CC'd in that mail. So they knew in November 2016, and this was Mr. Tebogo Mokoena, Mr. Lufa Labello, Akwesilo, Glengane Matebule. Now, you would notice that Mr. Tebogo Mokoena, Lufa Labello, Glengane was in the meeting with Mr. Moffley later on when they gave Mr. Moffley other instructions. But in November, it was very clear to them and to me what the terms of reference would be. So they never objected against it, they never said anything. In fact, Mr. Moffley was then appointed by them on those terms that were that were expressed to me, and I think that is relevant because those very same people who knew the exact terms of Mr. Moffley later said to Mr. Moffley, no, you misunderstood our terms. So I just wanted to...
Thank you for that addition. I wanted you to look, please, at the confirmatory affidavit of Mark Kingen, which appears at page 730 to 733. Mr. Kingen records in paragraph 3 that he was approached by your lawyers with a request to consult and provide information regarding his recollection of a meeting held on the 31st of October 2019, attended inter alia by him, Mosito, Ledwaba, and Motley. That's correct?
Yes, Chair.
And what Mr. Kingen does is to give his recollection of that meeting in the affidavit, and I'd like to direct your attention specifically to paragraph 9 on page 732, and this is what Mr. Kingen says. I further recall that during this meeting I gained the distinct impression that Motley had been coerced into preparing the addendum report. Given some of the words used during the engagement, it was my perception that the purpose of the instruction to prepare an addendum report was to, inverted commas, get Symington by whatever means possible. Is that what Mr. Kingen told you?
Yes, Chair, and the relevance, of course, is that the meeting was held and Mr. Kingen was in the meeting with Mr. Moffley when they asked him about this addendum report in 2019.
Thank you. Then, going back to your main affidavit in reply, at paragraph 682, you then deal with the affidavit of Mr. Makakela, is that correct? At page 682.
Yes,
and similarly, you set out a detailed version of events in which you take issue with some of what he has said, correct?
Yes, Chair, I did.
Could I direct you to one particular issue? It is on page 685, and it is under the heading, the issue of whether the Hawks were aware of Makakela's opinion. Just pausing there, why for you is it important to establish whether the Hawks were aware of Makakela's opinion?
Well, Chair, it's later when Advocate Sean Abrams withdrew the charges against Mr. Gordon and Pillay and Magashula on the early retirement issue. That was on 31st of October 2016. Mr. Abrams wrote a letter afterwards to the head of the Hawks and asked, but why wasn't my memorandum of 2009 available to the Hawks? And the nuance there I read is that he was asking sort of if this memo was available to them, then you know, why was it not handed over to the NPA? And so when we discovered that Mr. Mapakela also gave a legal opinion back in November 2014 about the lawfulness of Mr. Pillay's early retirement, it became relevant to understand, but then why was this a piece of information which is, which advised SARS very strongly that the early retirement of Mr. Pillay was in fact lawful? Why was this opinion then not available to either the Hawks or the NPA? Because certainly it was available to SARS, and anybody interested in the rule of law would have handed this legal view, at least, over to the Hawks to consider. And so would anybody who is interested in the rule of law have handed over my memorandum of 2009 to the Hawks. And this is the relevance of it.
Thank you. At paragraph 48 on page 685, you say that in your main affidavit you dealt with what was relayed to you regarding a meeting held between Makakela, Kingan and Broughton on the 16th of April 2018, and you asserted that during this meeting Makakela informed Kingan and Broughton that he had previously provided his November 2014 opinion to the Hawks. You explain in 49 that Mr. Makakela does not directly deal with your affidavit, but in an affidavit, a further affidavit, his affidavit, he records his responses to queries addressed to him by the Commission, and what he says is firstly that he had no knowledge whether Brigadier Kaba was aware of his opinion, dated the 5th of November 2014, and secondly that he had never provided his opinion to SARS. You've said that those allegations contradict the allegations in your affidavit, but because you do not have direct knowledge of what was discussed at the meeting of 18 April 2018, it was necessary to consult with Broughton and Kingin on the issue.
Yes, Chair.
What you've done in paragraph 52 is to quote from Mr. Broughton's confirmatory affidavit. Is that correct?
Yes, Chair.
Could I then just take you to the relevant parts of what Mr. Broughton has confirmed to the Commission? 5.3, at the end of the meeting on 16 April 2018, I asked Mr. Makakela what he meant when he said that he had an, inverted commas, ethical problem, close inverted commas, with the investigation of the early retirement of Mr. Pillay. 5.4, Mr. Makakela explained that his view was that there was nothing illegal in the early retirement of Mr. Pillay. He explained that he had sent SARS a written opinion explaining his views on the early retirement. Mr. Makakela explained that he had also been contacted by members of the Hawks in the course of their investigation. He said to me that in this meeting he had expressed his views that there was no illegality in the early retirement and that a member of the National Prosecuting Authority was also present at the meeting.
Indeed.
Then in 5.5, after the meeting with the Hawks, Mr. Makakela said he received the request to assist in obtaining a statement from Mr. Symington, and that because he had told both SARS and the Hawks what his opinion was concerning the illegality of the early retirement, when he forwarded the mail to SARS, he wanted to express very clearly that he did not want to participate in that investigation. And then jumping to para 6 of Mr. Broughton's affidavit, he says as follows: I had come to know about the, inverted commas, hostage incident between Mr. Symington and the Hawks through the media and had found it very peculiar and irrational. But after Mr. Makakela explained why he had sent the email refusing to get involved, using the phrase, inverted commas, ethical reasons, close inverted commas, did it make sense why it was so important to retrieve Mr. Makakela's email? The reasons behind Mr. Makakela's email was that an independent attorney acting for SARS had advised SARS in writing that the early retirement was lawful and had expressed this opinion to the Hawks and a member of the NPA. In short, the reasons behind his email put the, inverted commas, hostage incident, close inverted commas, in a clearer and more serious context. But further than that, questions are raised as to how neutral the criminal investigation was. So you can confirm that that is the gist of what Mr. Broughton explained to you about what he had established in a meeting on the 16th of April 2018 from Mr. Makakela himself.
Indeed, Chair.
Thank you. Could I then leave your additional affidavit and take you to another affidavit in SARS Bundle 03? And it is an affidavit that has been filed before the Commission by Mr. Mayani. And you find it in Bundle SARS 03, page 12 to 37.
Yes, Chair, but before we go there,
Is there something else you'd like to point out?
yeah, just on Wayne's
Mr. Makapela.
affidavit,
Yes, okay.
back on page 687.
Certainly, go ahead.
Just wait for us, 687.
It was on 687.
Okay.
In Mr. Mapakela's responding affidavit, he denies explicitly that he didn't hand over or share his written opinion dated November 2014. And so, which I...
Did you share it with whom?
With the Hawks or the NPA.
Okay.
He didn't deny that he shared his view with the Hawks or the NPA. And so a denial was focused on the written opinion of November, which he denied and which may be so. I've got no... But what happened was that he had a meeting with the Hawks and the NPA where he shared his view with them, not necessarily in writing and not that document, but he shared the outcome of his research. Thank you, Chair.
Well, if he didn't share his written opinion with the Hawks, do we know how the Hawks would have known about the fact that the email that they demanded from you had a reference to him having given an opinion or refusing to get involved because of ethical reasons? Do we know?
Well, the only assumption I can make out of that, and I think I did draw an inference out of that in one of the affidavits, either the main or the responding, is that the Hawks must have had some interaction with Mr. Mapakela on the early retirement matter. And that is why then the Hawks forwarded that email, that letter from Mr. Pretorius, not directly to SARS, but to Mr. Mapakela, and then asked Mapakela to forward the mail or to make arrangements for me to do the affidavit. So there must have been something there which made the Hawks think, or that that they should write to Mr. Mapakela. And my suspicion is that that arose out of the meeting where he shared his views with the Hawks, and it then so happened, apparently, that a member of the NPA was in that meeting as well.
Mr. Franklin?
I'm not sure whether that answered your
Yeah, well,
okay.
it's okay. Well, Mr. Mapakela had been involved in a particular matter, namely to give an opinion to SARS about Mr. Pilay's early retirement. Other than that, as far as you know, he had not been representing SARS in its interactions with the Hawks, or you. Is that correct?
No, I'm not aware of any. Well, he certainly didn't interact with me.
He did not represent you.
No, sir.
And you are unaware that he may have represented SARS in its dealings
Chair.
with Hawks. You don't know.
The first time that I really became aware of this, of the firm of attorneys and Mr. David Mapakela, was his name in that email. I've never dealt with them before.
Yeah, well, it's just that one wonders why the Hawks would have decided that they should send that email or letter to him rather than sending it to SARS. Mr. Franklin, you might be able to throw light.
I think you've elucidated it, Chair.
Yes. Okay.
Thank you. I had asked you to look, please, at, still in SARS 03, at Mr. Mayani's witness affidavit, which appears at pages 12 to 37. Do you have that?
Just give me a page and date.
It's at the beginning of the file, page 12. Mr. Mayani has responded to various of the allegations made against him by a number of witnesses, including you. And he deals with your evidence at page 21 from paragraph 33 until paragraph 51. Page 21 to page 25. Have you read what Mr. Mayani says in relation to your evidence?
Yes, Chair, I did.
And is it correct that this affidavit came to light subsequent to you having deposed to the affidavit in reply, which we looked at a few moments ago?
Yes, Chair.
But if I could take you to certain of the allegations made by Mr. Mayani, paragraph 33 on page 21, this is really a summary which he makes. He says, in essence...
At what page? I'm sorry, Mr. Frank.
21,
Okay.
Chair.
Yeah, you may continue.
Thank you. In essence, Mr. Vlok Symington's evidence against me is intended to support the theory that I was part of a state capture-inspired conspiracy aimed at the dismissal of Minister Gordhan by inter alia 1, knowingly laying false charges against him, 2, committing perjury in denying that I was the complainant in Mr. Gordhan's criminal case, and 3, fraudulently or actively concealing evidence which was exculpatory in respect of Mr. Gordhan's alleged involvement in the Pillay retirement issue. He then turns to deal with those topics. I'm interested in the third one for present purposes. He addresses that in paragraph 36 on page 22. And if I may read that out to you, I now deal with the main thrust of Mr. Symington's testimony, namely the unlawful concealment of exculpatory evidence in the form of 1, Mr. Symington's 2019 memorandum, which allegedly found that the Pillay retirement scheme was lawful, and 2, the legal opinion of an external attorney by the name of Mr. Makakela, who had also concluded that the Pillay retirement scheme was lawful. And then 37, the thesis is that had the Hawks been given these 2 documents, then the charges would not have been pursued and Mr. Gordhan and others would not have been prosecuted. Support for this theory is also based on the fact that in its statement in subsequently withdrawing the charges, the NPA cited the belated emergence of the Symington memorandum and its alleged refutation of the requisite element of mens rea, brackets, subjective intention, close brackets, on the part of Gordhan. And then paragraph 38 is the important one, and I'm going to ask you to comment on it. The above theory is unfortunately based on a false premise, namely that the Symington memorandum had declared the Pillay retirement to be lawful and problem-free, apparently without any qualification. This is the biggest lie ever told in support of the unfounded allegations against me, more particularly in that. And then he gives 4 reasons why he comes to that conclusion, and he does so with reference to certain parts of your memorandum. I take it you've read those reasons.
Yes, Chair.
And then he says in 39, how anyone can ever construe that document as a legal opinion confirming the lawfulness of the scheme is confounding and palpably false, or at best misleading. So Mr. Mayani makes very strident allegations against you, and in effect contends that your memorandum does not in any way indicate that the Pillay retirement scheme was lawful. What's your response?
Well, Mr. Chair, Mr. Pillay would have, approached me in March 2009, wanting to know whether what he wants to do is lawful. There would have been no other reason for him to ask me that, because my expertise lied, one half of it lied in the area of retirement funding from a legal point of view. And so the intent is, at least, but I know mine, was to give him my version of the outcome of my research about the lawfulness of these things. And I, in fact, later on, when Mr. Pretorius wanted to know how did I arrive at the outcome of my 2009 memorandum, I went into the details of the law. There is more than one law involved there. And there I went into the detail on how I arrived at the outcome of my memorandum of 2009. There was no other reason that I wrote and did the research, because my research that I did back in 2009 was about the lawfulness of whether this can be done. So I really regard this as absurd then to say that the outcome does not talk to the lawfulness or otherwise of the scheme.
Thank
I
you.
just want Mr. Franklin to quickly go to that memorandum.
Yes, I have that, and that was on my next document, Chair. It's bundle 02, SARS bundle 02,
Yes, okay.
at page 202.
Thank you. Well, I could ask you this question, Mr. Symington, while I'm waiting for the file to look at the opinion briefly. Is there nothing in the memorandum that makes it clear that what you were investigating was whether Mr. Pillay could be allowed to retire early? Is there nothing that says that is to that effect in the memorandum?
Chair, I think we need to look at the wording then.
Yes, 202.
202.
202. And perhaps we can start at the beginning to answer the Chair's question. So firstly, this is a memorandum addressed from you to the Commissioner. Its subject is early retirement, Mr. Ivan Pillay, and the background is as follows. Mr. Ivan Pillay requested me to consider certain elements that form part of his decision to apply for early retirement from the Government Employees Pension Fund, the GEPF. These elements are: 1, his application for early retirement from the GEPF; 2, his application to the Minister of Finance to waive the early retirement penalty; and 3, his request to be appointed on contract after his early retirement from the GEPF. So just stopping there, are those the three elements that would make up this, what's known as the Pillay retirement package?
Yes, Chair, indeed.
And then you've headed, under the heading, the technical position, you've said, approached individually, all three elements are technically possible under the rules of the GEPF, read together with the employment policies of SARS. Mr. Pillay has reached the required age for retirement. He is entitled to request the Minister to waive the early retirement penalty, and no technicality prevents SARS from appointing him on a contract after his retirement from the GEPF. Is that the summary of your
Yes, Chair.
advice?
Yes, Chair, indeed. And there, I think, in my mind, it is very visible that to have arrived at this outcome, I researched the law, and it is not an easy road to get to ultimately get to the rules of the GEPF, but that is where ultimately the law takes you. Starting off with the SA Revenue Service Act, then going into the Public Service Act, which then leads you into the Government Employees Pension Law, which then takes you into the rules of the fund itself. And by saying that he has reached the required age for early retirement, now SARS doesn't have early or late or middle retirement ages. The early retirement age for SARS and normal retirement and late retirement is set out in the Public Service Act, not in any SARS a policy and so on. So the only way that I could have, as an example, arrived at that outcome was my research into the Public Service Act. Similar to the next part, which in layman terms, because that's how people refer to it, says that that he is entitled to request the minister to waive the early retirement penalty. Now that, again, is done in terms of the Public Service Act, but here, of course, I use layman terms, which the fund itself uses. It is actually not the minister that waives any penalty. It is actually done by the fund itself together with the participating employer. But I think the point I'm making is the outcome of this could not have been reached without an in-depth legal research.
Well, I don't know about in-depth, Mr. Symington. You did say yesterday that the commissioner at the time, when he sought legal advice, mostly wanted just the outcome.
Yes.
And wouldn't be interested in a lot of things which I assume would be how you got there.
Indeed, and that is why the memo reads like it reads, but sorry.
What was your position at SARS at the time of preparing this memorandum?
I was an executive in heading up the so-called product oversight division of SARS, which deals with the legal framework for all our products like VAT, corporate income tax, personal income tax, and so on. But up to that point, maybe a little bit earlier, my whole career at SARS was focused on matters relating to retirement funds. And I was known inside SARS and outside of SARS as a knowledgeable individual on legal matters relating to retirement funds.
Did SARS have a dedicated legal department?
Yes, Chair.
Were you in that department?
Yes, Chair.
So the department in which you were was basically the legal department of SARS as well?
Well, yes. So it was
a
called
section or unit that would be the legal unit or section.
It was a whole legal unit which
Yeah.
was overseen by Mr. Lowe. He was the head of the unit, being the chief legal officer.
Yeah.
And I operated within that unit.
Okay, so Mr. Lowe, his position was chief legal officer.
Yes, Chair.
Okay, all right. And was giving legal advice part of your duties?
Well, it was legal advice, but mostly, I was giving advice about the interpretation of the laws that we administer at SARS.
Yes.
Yeah, and there's a number of them.
Yes, yeah. Not this type of issue, retirement and so on.
Well, yes, but earlier in my career.
Earlier, but I mean,
Yes.
when
But at
you
that
did
point
this,
in time, I moved on in my career.
But you were regarded as having a lot of knowledge on retirement policies and law in relation to SARS.
Yes, Chair, and that would have been the reason that Mr. Pillay came to me and to no one else.
Yes. Yeah, well, I see that part of one of the topics you deal with there is financial risk, which obviously is not law, you know. And the memo, although it does say you were requested by Mr. Pillay to consider certain elements that form part of his decision to apply for early retirement, I think part of what Mr. Mayani is saying, you are not saying in your memo you had been asked to consider the lawfulness of the early retirement. And of course, when one reads a legal opinion, one is used to the person who gives the legal opinion articulating what the question is that he or she is asked to give an opinion on, and usually it will be the lawfulness or otherwise of something, and whether something is constitutional or not constitutional, and so on. So which is missing here. And in the memorandum, there appears, as far as I can see, there does not appear to be any reference to any legal instrument. Am I right? You may
Yes, Chair,
have,
but
before you prepared, you
yes.
may have consulted a lot of legal instruments.
Absolutely, but this is...
But in the memorandum, there seems to be no reference to any legal instrument that may have, or that you relied upon for anything in regard to this.
Yeah, so this is the way that we would normally write to any commissioner, is that you, they are normally only interested in the outcome of your research. So this memorandum was therefore, it was addressed to Mr. Gordon at that time. He was the commissioner. I knew sort of the way that he liked to be informed, and well knowing that if he wants to know more about what I've written, then he would ask me to go into more detail. So normally one would give almost an executive summary of the outcome of what you...
No, I hear what you say. I hear what you say, but I think what cannot be denied is that, if my reading of your memo is correct, is that there is no reference to any source on which the opinion may be based, such as a statute or regulations and things like that.
That is so true, yes.
That is one. And the memo doesn't make it clear that what you have been asked to answer is the question whether Mr. Pillay's early retirement would be lawful or can be approved or anything like that. It doesn't make that clear. So it may well be that, to the extent that Mr. Mayani is maybe saying, the memorandum doesn't have the usual features that one expects to see in a legal opinion. It may well be that he shouldn't be criticized for saying that. What do you say to that?
Chair, that may very well be.
But you say you intended it as a legal opinion.
Yes, of course.
Yes.
What I need to maybe point out as well is that my reference to the GEPF, the rules of the GEPF, is in fact
That's a legal
law.
instrument.
No, no, no. It is a part of the law.
Yes, that's what I'm saying. That you are saying that's,
yes.
that's a legal instrument.
Yes, and this is ultimately where
you
you would find the validity of the early retirement, the validity of the waiving
Yes.
of the penalty. And the GEPF is not like any other fund. It is not a private fund. It is established by law, not in terms of a law, but by law. And you would understand the difference between the two. So the reference to the rules of the GEPF is in fact a reference to the law.
Okay, all right. Mr. Franklin.
Thank you. Perhaps just to conclude on the issue.
Yes.
Mr. Symington, what was the point of this memorandum? Why were you approached to give it?
Chair, I think I explained it at one point, but I was known as the individual in SARS to go to if you need to know anything about a pension funds or a pension law. And so, yes, Chair.
All right. And the propositions that had been put to you, as I understand it, are recorded under the background. In other words, that Mr. Pillay had made a request, and the request basically consisted of three parts. The first was he wanted early retirement from the GEPF. Secondly, he wanted the Minister of Finance to waive his early retirement penalty. And thirdly, he wanted to be appointed on contract after his early retirement from the GEPF. Is that correct?
That is so, Chair. And to add to that, all three of those is governed by law. So the reason that you would have asked me to do this was to check on the validity of it. And certainly, when I use words like technical position, it is the legal technical position. And so that was why that was not why I wrote it, but this was the outcome of whether it is lawful or not.
And then in response, as I understand it, to those three requests and three propositions, you record your conclusions under the technical position.
Yes, Chair.
Second paragraph, you say, Mr. Pillay has reached the required age for early retirement. Is that addressing question one?
Yes, Chair, it does.
Then you say he's entitled to request the Minister to waive the early retirement penalty.
Yes,
Is
Chair.
that addressing number two?
Yes, Chair.
And then you say, and no technicality prevents SARS from appointing him on a contract after his retirement from GEPF. Is that addressing issue three?
Yes, Chair.
So are you saying you may not have used certain language that maybe one normally expects in a legal opinion, but you say one, to, you were asked to give an opinion.
Yes,
To give that opinion, you needed to look at the law with special reference to pension law and the rules of the GEPF.
Yes, Chair.
And that you answered those three, you dealt with those three issues on the basis of pension law and the rules of the GEPF. Is that correct?
Yes, Chair. In respect of the first two issues, in respect of the third issue, I was not relying on a pension law. That's labor law, employment contract, which is one of the fields that I am interested in as well. And I have, in fact, done some work at SARS in fields, as an example, as you would know, very complicated area of the difference between an independent contractor and a common law employee and those sorts. So I drew out of that experience to answer number 3. Chair.
Okay, no, that's fine. Mr. Franklin, I see we way past the tea break.
Yes, thank
time. But I don't know whether I probably should just take the break now and you can finish up.
I should not be long after tea.
Yes, okay, all right. We'll take the tea adjournment and we will resume at 10 to 12. We adjourn. I see they have put here, in addition to the file that I had before, the file that relates to your next witness. Is that because you asked them to do that, or?
No, there's still some
Okay, all right.
practical issues to attend to on that
Yeah.
front. I'm still in file SARS bundle 03.
Okay, that's the one I have now.
Thank you. Mr. Symington, there's just one further aspect of Mr. Mayani's version that I want to put to you, and that's at paragraph 51 on page 25. You have that?
Yes, thank you.
It seems this is Mr. Mayani's response to the evidence about the hostage incident as you have described it on the 18th of October 2016. And what he says is, regarding his internal grievance about being allegedly blocked by my bodyguard from leaving a room and for which I had apologized, these are human resources issues which have no bearing on alleged state capture. There is no need to dwell much on such spurious allegations. What's your response to that?
So, a chair, I mean, sure, it may be a human resource matter if one looks at what a grievance is. But the whole incident of 18 October 2016 was instigated by Mr. Mayani. So it's much more than simply a human resource issue. He was effectively in a control of what happened inside that room. Mr. Atiti and Mr. Mayani, and we learned this afterwards, was on a phone with each other during the incident. So, sure, it's a human resource issue, but only in as far as it goes to the grievance itself which I lodged.
Thank you. And then, finally, if I could ask you to go to SARS bundle 02. Page
Are you still
261.
going to come back to this one?
No, not
Okay.
anymore. Thank you. Chair. You have page 261.
I've got 261.
Thank you, Chair.
Just a moment. Yes, Mr. Franklin, thank you.
Yes, we looked at this string of emails yesterday. They were sent in the aftermath of the incident on the 18th of October. You testified that you'd had a meeting, you'd got some explanation from Mr. Mayani, you didn't think it made any sense. You set out in a lengthy, an email on the 21st of October why you didn't think that the explanation given by Mr. Mayani made any sense, and that's the email at page 262. At 261, he responded to you in the email at the bottom of the page, and we went through that yesterday. Can I direct your attention to the email at the top of the page, 21 October 2016? This is you writing to Mr. Mayani and Mr. Lowe regarding Ivan Pillay. And could I ask you to look at the last paragraph? You say, I really hope we can get this whole thing behind us as soon as possible. This has happened at a time when I'm still trying to process why units and projects that I built and created from scratch producing significant tax revenue each year was reallocated elsewhere. Now, you've been an employee of SARS since 1990. You were there during the era that Mr. Mayani was Commissioner. Can you put that comment in perspective, please? What were you referring to?
So, Chair, maybe, and I'll hold it short, but maybe I must go back to meeting which in my recollection, happened around August 2015, where the new model of SARS, as it was apparently designed by Baines, was presented to the executives of SARS, and as a fait accompli. We've never participated in any aspect of the design. We were never consulted about our divisions that we managed at that point in time, about our expertise or anything. And when we saw this model, it soon, for a number of us, we couldn't see ourselves in that model. It was the model was foreign to us. Now, I must emphasize that as SARS employees, we have gone through many changes. So we are used to a change. We are resistant to a change, as you would normally expect of employees who are not used to change. But this model, because I don't want to speak on behalf of others, I was not able to see how this model is going to be more efficient than what we had at that moment. Number one. Number two, I couldn't see myself in that model. Up until that point in time, I was heading up a division within legal, which I explained earlier was called product oversight, where most of the design of our products happened from a legal point of view. And as what I refer to as something on the side, I was asked back in 29 or so to establish what we refer to as the VDP unit of SARS, the Voluntary Disclosure Unit of SARS. And so that was set up by myself, and over the years, that unit has produced a significant amount of money. On average, we were on about 2.5 billion rand a year via the VDP process. And that unit was just removed out of my care. It didn't fit into where it used to belong. So, and that is what I meant when I wrote this part in the mail to Mr. Mayani. It was just to express that what has happened now, this whole incident thing, a bizarre, which one would never have expected to happen to anybody in SARS, was now added to the a confusion about this model and where I fit into this model. And so, Chair, that is where that part came from.
Thank you, Mr Symington. Unless there's anything else you wish to bring to the attention of the Commission, that concludes the testimony of Mr Symington.
Thank you, Chair. Just maybe one word or so, Chair. First of all, just thank you for the opportunity. Many of us have lived with what we've experienced as a nightmare, and this is, being given the opportunity to share what happened to us is a relief in more than one way. I myself have lived in SARS. I've seen SARS when it was referred to as inland revenue before 1994. I've lived in it when Mr. Gordon and Pillay and Mr. Abergefell drew us into a whole different direction, modernizing us. So much so that by 2008 or 9, we were recognized internationally as one of the best tax administration, one of the most efficient tax administrations. And to then see this happening to SARS in a very short space of time, from 2014 up to, well, it was less than 4 years, where we could visibly see that our efficiency rate has dropped, and you could see it in what we call the buoyancy rate, which is just a measure to measure our efficiency, has dropped in Mr. Mayani's time. And so I just hope, Chair, that this will never happen again. And I think your Commission is instrumental in ensuring that it won't ever happen again, Chair. Thank you very much.
Thank you, Mr. Symington. Thank you for availing yourself to assist the Commission. You are now excused. Thank you. Mr. Franklin.
Thank you, Chair. Chair, the next witness that we intend calling is Mr. Vlok Symington. There are, however, practical issues which need to be attended to, consequent upon the arrangements that have been made with the SSA. There is going to be a substitution of the existing affidavit by a redacted affidavit. We had wondered whether it would be possible to proceed without that document, but I don't think practically it will.
Okay.
And so we would ask for the time to make those practical arrangements and then to commence with the leading of Mr. Symington, Mr. Vlok Symington. I can't tell the Chair exactly how long that will be.
Yes.
But I imagine it will be more than half an hour.
Well, in that event, because we were going to take an early lunch at 12:30, maybe we may as well adjourn now. Maybe we should, if we adjourn now and take the same amount of time that we would have taken if we had adjourned at 12:30, then we would resume at 1:30. But then at 2, there would be that interruption. So I don't know what you think, whether...
Yes, I think, Chair, that would be perfectly in order. That would give us enough time to get the files in order and Mr. Vlok Symington ready. And we'll have half an hour. It'll be interrupted for a while and then we'll continue. So that's in order from our side. Thank you.
Okay, all right. Okay, let us adjourn now, and then we will resume at 1:30.
Thank you, Chair.
We adjourn.